Your Honor, has the prosecution provided any actual evidence to substantiate the presumption of jurisdiction? Abstract jurisdiction is the cornerstone of any court's authority to hear and decide a case. Without jurisdiction, both personal and subject matter, the legal process collapses into invalidity. Despite this foundational principle, courts often proceed based on unchallenged presumptions of jurisdiction, particularly in administrative and traffic matters, where the accused frequently lacks a nuanced understanding of their rights. This article critically examines the presumption of jurisdiction as it operates in contemporary courts and explores the burden of proof required to substantiate jurisdiction. It argues that the failure to demand actual evidence to substantiate jurisdiction undermines the integrity of judicial proceedings and erodes constitutional protections. Introduction. Jurisdiction is power, wrote Justice Felix Frankfurter, and without it, a court's rulings are nullities. Yet, in countless cases across administrative and lower courts, jurisdiction is presumed, not proven, and this presumption is rarely challenged. The problem is exacerbated in traffic, tax, and other quasi-criminal proceedings, where individuals are often unaware of their right to demand proof of jurisdiction. The presumption of jurisdiction can often function as a procedural shortcut, where the mere filing of a case or the presence of a defendant is assumed to establish the court's authority. However, as courts derive their jurisdiction from constitutional and statutory grants of power, this presumption must be substantiated with evidence, not assumed. This article explores the nature of jurisdiction, the evidentiary requirements for its substantiation, and the constitutional implications of failing to challenge its presumption. Understanding jurisdiction. The types of jurisdiction. Subject matter jurisdiction, the authority of a court to hear cases of a specific type based on statutory or constitutional provisions. Personal jurisdiction, the authority over the individuals involved, often tied to geographic location or voluntary submission. Territorial jurisdiction, the geographic scope within which a court may exercise authority. Without all three, a court's decisions are void and can be challenged at any stage. The constitutional basis of jurisdiction. Jurisdiction is derived from the Constitution and legislative enactments. For example, federal courts derive authority from Article 3 of the Constitution. State courts operate under state constitutions and statutory frameworks. The presumption of jurisdiction often hinges on implied consent, such as through residency, licensure, or engagement in regulated activities. However, these presumptions are not evidence and must be substantiated when questioned. Third, the presumption of jurisdiction in practice. A. Traffic and administrative cases. In traffic courts, jurisdiction is often presumed based on the issuance of a license or registration. However, these are contracts voluntarily entered into by individuals, often without a full understanding of the implications. Licensure and registration do not inherently waive constitutional rights or provide blanket jurisdiction to administrative tribunals. B. The role of voluntary compliance. By applying for licenses or registering vehicles, individuals often unknowingly consent to be governed by administrative rules. This implied consent is treated as evidence of jurisdiction but remains unsubstantiated when challenged. C. Burden of proof. Courts and prosecutors frequently assume that jurisdictional facts are self-evident. This assumption contradicts the principle that jurisdiction must be proven, not presumed. In Hagan v. Utah, 1902, the Supreme Court emphasized that jurisdictional facts must be demonstrated with clarity and evidence. The legal standard for proving jurisdiction, or evidence. The prosecution bears the burden of proving jurisdiction. This includes documentary evidence, statutes, regulations, or contracts that establish the court's authority over the individual or subject matter. Factual evidence, specific facts demonstrating the individual's connection to the jurisdiction, e.g., residence, activity within the court's geographic area. B. Judicial missteps. Courts often conflate presence in a courtroom with consent to jurisdiction. However, mere presence does not establish jurisdiction, as demonstrated in Pennoyer v. Neff, 1878, where the Supreme Court held that jurisdiction requires explicit and demonstrable authority over the defendant. V. Challenging the presumption of jurisdiction. A. Key questions to ask. Has the prosecution provided documentary evidence of jurisdiction? What statutory or constitutional authority explicitly grants the court jurisdiction over this matter? Has the defendant voluntarily and knowingly consented to the tribunal's authority? B. Legal tools for challenge. Motion to dismiss. Argue lack of jurisdiction as grounds for dismissal. Request for proof. Formally demand that the prosecution present evidence substantiating jurisdiction. Judicial review. Escalate jurisdictional disputes to higher courts when lower tribunals fail to substantiate their authority. The constitutional implications of jurisdictional presumptions. A. Due process violations. Proceeding without substantiating jurisdiction undermines the due process rights of individuals. The 5th and 14th Amendments guarantee that no one shall be deprived of life, liberty, or property without due process of law, which includes jurisdictional safeguards. Erosion of individual liberties. The unchecked presumption of jurisdiction often leads to broader governmental overreach, particularly in administrative and traffic contexts, where tribunals operate under relaxed procedural standards. 7. Reforms and recommendations. A. Shift the burden of proof. The burden of proving jurisdiction must rest unequivocally with the prosecution. Courts should require clear and convincing evidence before proceeding. B. Educate defendants. Public awareness campaigns and legal education initiatives can empower individuals to recognize and challenge jurisdictional presumptions. C. Judicial oversight. Higher courts should enforce stricter standards for proving jurisdiction, ensuring that lower tribunals do not rely on procedural shortcuts. Conclusion. Jurisdiction is not a mere formality. It is the bedrock of judicial authority. Allowing courts and prosecutors to proceed based on unchallenged presumptions of jurisdiction risks eroding constitutional protections and the integrity of the judicial process. By demanding actual evidence to substantiate jurisdiction, defendants can ensure that their fundamental rights are respected and upheld. Courts, in turn, must rigorously adhere to the evidentiary standards required to establish their authority, reaffirming the rule of law and the constitutional principles that undergird it. The question is simple. Your Honor, has the prosecution provided any actual evidence to substantiate the presumption of jurisdiction? Without a clear answer, no court has the authority to proceed.